Minutes each. We'll begin with Mr. Burton. The floor is yours, Mr. Burton.
Thank you very much, Mr. Chair. My area of expertise is China's domestic politics and China's foreign policy. So with that in mind, I'd like to pick up on 2 points raised by Minister Champagne when he appeared before this committee last week. And they are that the minister said that henceforth state-owned companies' investments in Canada will be approved only in exceptional circumstances. And secondly, he told you that last November, after a national security review, based on intelligence that he had received, Minister Champagne ordered 3 Chinese resource companies to sell their interests in Canadian critical mineral firms, lithium. But the fact is that all Chinese global enterprises are fully integrated into the PRC party, state, corporate, military, and security apparatus because, as Party General Secretary Xi Jinping has put it, party, government, military, civilian, and academic, east, west, south, north, and center, the party leads everything. There are no Chinese industrial enterprises existing independently from China's party state. Huawei, for example, does not self-identify as a Chinese state-owned enterprise, but like all PRC institutions, its org chart suggests that Huawei's Chinese Communist Party branch takes precedent over the Huawei Board of Directors in corporate decision-making. Huawei's corporate purpose is to compete prudently in foreign markets and make money, but as the Government of Canada determined in banning Huawei's participation in the 5G software and hardware, Huawei's raison d'etre is not just about economic profitability, but to serve other PRC regime geostrategic purposes that threaten Canada's national security as well. Chinese law requires that all companies and individuals cooperate with their intelligence establishment and hide that cooperation. That, combined with the Chinese regime's unrelenting cyber and human source spying on our parliament, political parties, government departments, universities, and businesses, is reason enough to conclude that foreign investment from China must be subject to the most stringent national security test, regardless of what sector or industry the proposed investment may target. For example, China's so-called police stations are overseen by Chinese diplomats in Canada to coordinate Chinese Communist Party United Front Work Department operations to menace and harass Canadian Uyghurs and Tibetans and human rights activists, subvert Canadian officials, facilitate Chinese Ministry of State Security espionage operations, hand out money for election interference, and so on. If these police station operations are inconvenienced by an RCMP vehicle being parked outside the station, whether it's in Markham or Richmond or Montreal or wherever, it is easy for the Chinese authorities to simply inform a Chinese business invested in Canada that the police station will relocate to your premises, and please issue fake letters of invitation to facilitate false visa applications for Chinese police or People's Liberation Army military researchers to enter Canada on false pretenses for covert or gray zone operations to transfer dual-use technologies to the Chinese regime. We have many examples of this, including evidence given by Canadian government immigration officials in this regard. Any intellectual property that any Chinese concern becomes privy to through its foreign investment in a Canadian partner is, as a matter of course, going to be covertly transferred through Chinese Communist Party channels to whatever elements of China's Communist Party regime can apply the Canadian proprietary technology or manufacturing process to further China's overall diverse regime interests. We have many examples of this, too. Finally, I urge a more coordinated approach to all this. Australia's Foreign Investment Reform, entitled Protecting Australia's National Security Act of 2020, was enacted to follow on Australia's Foreign Influence Transparency Scheme Act of 2018. I should point out that implementing this latter act, the Foreign Influence Registry, did not instigate any rise of anti-Asian racism in Australia. I strongly recommend to this committee that Canada look carefully to Australia's strengthening of laws against covert foreign influencing and espionage, curbs on proxy foreign donations to political parties, and better controls over the security of critical infrastructure. Modeling on Australian legislation could allow Canada to make our legislative improvements in a much shorter time frame. The longer we delay, the worse it gets.